Our next guest worked in the Manhattan DA's office and has major doubts about the viability of the case. Former prosecutor Elliot Felig is here to explain. Elliot, good morning. All right, you got three problems with this.
Three questions that have not been satisfactorily answered that make me really doubt the viability of this case and make me question the motivation behind this prosecution. First and foremost, the timing. The underlying acts occurred 7 years ago. They've been known publicly for 5 years. President Trump, Donald Trump, has been out of office for 2 years, so any presumable shield against prosecution is long gone. So why is this case being brought now? Is it just a politically motivated response to the criticism Alvin Bragg received from his former deputy for not pursuing Trump for financial improprieties? That's what it looks like.
Okay. You also say that apparently somebody wrote a book about the situation and literally attacked Mr. Bragg, and now this is payback.
Well, that's what it looks like. Why else would you wait 2 years that he's been out of office to bring this case, unless it's in the immediate aftermath of the criticism from that book? I'm also curious, though, why are we even in state court? These are federal election laws. Presumably, they're typically and almost exclusively prosecuted by either the FEC or the Department of Justice. I'm not aware of any legal theory whereby these acts would constitute a violation of state law, but not also federal law. The only inference here is that the FEC and the Department of Justice, the Biden Department of Justice, looked at these facts and said there is no viable case here. I don't know anyone who would argue with a straight face that Alvin Bragg is somehow a more competent or respected prosecutor than Merrick Garland. Merrick Garland passed.
Right. The feds passed. The DOJ passed. The Federal Election Commission passed, and now the local guy who we've talked about with the crime situation here, he's going after him. You also suggest the John Edwards defense may come into play.
Absolutely. John Edwards was charged in 2011 under very similar circumstances in federal court where it belonged with violating campaign finance laws for having hush money sent to a former extramarital lover. His lawyers successfully defended the charge by saying, look, anyone would pay hush money, candidate or not a candidate, to spare themselves, their spouse, their family from embarrassment. That was a successful defense. It's a defense that's fully available here.
Right. So today the grand jury may hear from Robert Costello, who was an advisor to Michael Cohen.
Right.
And apparently Mr. Costello previously told the Wall Street Journal that Cohen told him he paid off Stormy Daniels to protect Melania, who had just had a baby, which was barren.
Right. Extremely unusual for grand jurors to hear from a defense witness. It's extremely unusual to even hear from a defendant himself or herself. That happened maybe in 2 or 3% of the cases I handled. But to hear from an actual defense witness, very, very rare. It's an uphill climb, though. So
ultimately, I read that the jury themselves will vote on whether or not to hear him. So we might not hear. Well, they might not hear.
That's possible. So first, the grand jurors have to vote if they want to hear from this witness. But remember, grand jury, very low bar. It's not like a trial. Trial, you need unanimous. You need beyond a reasonable doubt. Grand jury, you just need a majority of the grand jurors to say there's probable cause. So unless this defense witness blows everyone out of the water, unlikely to prevent an indictment.
Never boring. All right, Elliot, thank you very much for joining us.
My pleasure. Thank you.